Good afternoon. Like Stephen was saying, my name is Nick Pycha, and I am a staff attorney from Senior Legal Services. And I'm here to do a training on just the basics of estate administration here in Maryland. So I am from Senior Legal Services, and Senior Legal Services is a nonprofit through the Bar Association. Our program provides legal representation to seniors 60 and older that are residing in Baltimore City. And our office focuses primarily on civil issues, which involves estate planning, housing issues, as well as estate administration, which we'll be focusing on today. First, I wanted to kind of talk a little bit about the importance of estate administration, especially in Baltimore City. One thing that MVLS already covers is the tangled title issue in Baltimore City. It's also involved in other counties, but we see it most prominently in Baltimore City, where families in Baltimore City are still residing in properties where the title of the property is still in the name of the deceased relative. Estate administration is also important for preserving the family legacy and for preventing foreclosure and tax issues, which kind of ties into the tangled title issue as well. A lot of the times that some of those properties go into foreclosure or tax issues, and the families have a harder time navigating those issues because they aren't the property owner. And that also excludes them from certain benefits they would receive, such as the homestead tax credit and other things that require you to be the owner of the home to receive. And lastly, one thing I wanted to touch on was that estate administration is an area of law that doesn't receive a lot of support from other pro bono organizations or pro bono volunteers. From my experience, it's an area of law that has a very limited turnout for volunteers and organizations that are willing to assist in the pro bono field. So hopefully this training is to make this process a little bit easier to navigate, so there isn't that stigma that estate administration isn't something that volunteers want to take on. Is actually a great area to practice in if you're looking for something to for a pro bono case that doesn't require a lot of litigation, as a lot of this administration process will take place out of court. So just a little overview of what I'll be covering today. First, I'll be going over what property will be considered probate property and what assets will be considered non-probate and therefore wouldn't be subject to the probate process. I'll be talking about the differences between testate and intestate succession, and what determines a small and regular estate, as well as going over some of the process for opening an estate, the estate timeline, and a little bit about distribution and some things that you would likely expect to see when handling an estate administration case. And just one disclaimer I wanted to say before I get started is that this is just a basic overview of estate administration. I don't know all the ins and outs of estate administration, as there are a lot of nuance that can happen in estate administration, but this is solely to cover the basics of what you would expect to see in an estate administration case. And if you are a volunteer that would take on this case, a type of case like this, you would have the support of both of our organizations. If you take a case one from MVLS or from Senior Legal Services, and we would be able to provide you with support if you had questions or had things that you wanted clarified. So there is a lot of resources that can be used in this community, whether it be the Register of Wills or our offices or other attorneys in the area that would be able to help you. So today I'll be only covering the basics of everything, and I'm going to get started with probate versus non-probate assets. So one thing I like to do when a client comes to me with an estate administration issue is to look at the assets and kind of put them in two categories if possible, and that would be probate and non-probate. So probate assets are assets solely titled in the name of the decedent at the time of their death. And some examples of that could be real property, if they are the only ones on the title, or if they own property with multiple people and as a tenant in common, then their portion of what they owned as a tenant in common would be subject to the probate process. It would need to be part of their estate. Also, bank accounts that are only in the name of the decedent would be considered probate assets. Vehicles. So it would be important to look at the vehicle's title to see if there are multiple people on the title. A lot of times you will see a husband and wife on the title, and in that situation, the surviving spouse would receive the vehicle, and then that would be considered non-probate asset. With non-probate assets, these are assets that will be distributed outside of the estate process based on the way they are titled. They would be transferred as a matter of law. Some examples of that are real property. So this would include jointly owned property with the right of survivorship. So joint tenants, tenants by the entirety, or life estate deeds would all be examples of real property being a non-probate asset. And things like bank accounts that have a payable on death or trade on death account, or jointly owned accounts, these are going to pass directly to the beneficiaries named on those accounts or to the surviving owner of the account. Other examples that are pretty common that appear in estates are life insurance policies or retirement accounts with beneficiaries named, and those are also examples of things that would be handled outside of the estate. It would not need to be reported on the documents that I'm about to talk about for opening the estate. So once you have an idea of what assets will be coming through the estate, that is when you decide what estate type you would need to move forward with the probate process. And there are two main estates that I'll be covering today. There is a modified estate, but that's more of a streamlined process that I won't be covering today. So for today's purposes, I will only be talking about small and regular estates. The general rule for these estates are if the probate assets are under 50,000, then it's going to be considered a small estate. And if the probate assets are above 50,000, then it's going to be considered a regular estate. And the only exception to that is if the spouse is the sole legatee or heir at law, then a small estate could be considered 100,000. And then if it's over 100,000, where the spouse is the only heir receiving something from the estate, then it will be a regular estate. And these values are determined by the date of death value of the property. So, for example, the bank account, you would look at the date of death and what the amount was left in that account during that time. For other pieces of property, this could be an appraisal of the property. For real property, it could either be an appraisal or the SDAT tax evaluation value of the property, and that would be the value that would be determining how much the asset was worth for the gross estate value. Oh, there we go. And there also are two different types of estates: testate or intestate. So testate is when someone passes away with a will, and the will will be what provides the instructions for the first representative and how they will be handling affairs after the decedent has passed away. So the will is going to state who will be appointed as the first representative, the type of bequests that will be handled through this estate, whether there are any specific or general bequests, such as I'm leaving $1,000 to so-and-so, or I'm leaving this particular family item to a family member. These are all things that are going to be handled in the will, and the will should also include who is going to be receiving the residual estate, which is just the remaining of assets in the estate once the expenses and claims have been paid, if there are any, and that is going to be the remaining share that gets distributed to the heirs, or in this case, legatees. And other provisions that you might see in the will include tax planning sections, appointment of a guardian for a minor child, and survival clauses, which would state if we were to simultaneously pass away at the same time and there wasn't a way to determine who passed away first, it's a way to determine whose estate would be administered. For intestate, this is where someone has passed away without a will. And when someone passes away without a will, the Estates and Trust article dictates the parameters of the estate administration. So a good way to look at this is the state of Maryland's estate plan kind of governs over how the estate will be handled. So with the main difference with testate and intestate succession is the big difference is distribution and how distribution is going to be handled. And the recent update to the intestate succession law is a surviving spouse, when there is no minor children, will inherit the entire estate. However, if there are adult children that are considered stepchildren of the surviving spouse and not blood-related children, then the surviving spouse will receive the first 100,000, and then half of the remaining residual estate, and then the rest will be split among the children. And if there are no surviving spouses, and then the estate property will be divided equally among the surviving issue. And I kind of have made a little bit of a flow chart to kind of show how the intestate succession will work. So the first person to receive the estate will be the surviving spouse. If there is not a surviving spouse, then it will go to the children and to the grandchildren, and then it goes back up the tree to the decedent's parents. And that's where it gets a little bit tricky, because each surviving parent would receive a share of the estate. And if they had, and if one of those parents were to have passed away, then the deceased parent still gets a share, and then half of that share goes down their family tree. And it gets a bit complicated, but so for the purposes of today, I'm just kind of showing the direct line of succession here and what to expect. And a great resource is the Register of Wills. They have a lot of dedicated staff and employees that have been fully trained and have been working in this area for a long time, and they're a great resource to use to help you along the way to determine these kind of issues. All right, so next I'm going to be talking about opening the estate. And here is the list of documents and things that you should might need to open an estate here in Maryland. And this is a list that I pulled directly from the Register of Wills website. Most importantly, you will need an original death certificate that will accompany the petition for probate. Also, if the person has passed away with a will, the original last will and testament will be necessary to include as well. In some circumstances, consents to appointment might be necessary to have your client be appointed as the personal representative of the estate. For those type of situations, it's usually where there isn't a will and the person that wants to become the personal representative doesn't have the highest priority to do so. For a personal representative priority, this is governed by the Estates and Trust article, which kind of goes on to say that when there is a will, the priority of appointment is the person appointed in the will, then the surviving spouse would have priority, and then surviving children would have priority. And for intestate succession estates, you would look at and see if there's a surviving spouse, they would have first priority, then children, and then it would kind of go down the same succession for distribution I was talking about earlier. And lastly, the lowest priority would be all interested persons that have an interest in the estate, which would include individuals that are like bringing out a claim against the estate. Claimants can open the estate if there's no one else to do so. So it's important to take a look and see exactly who is your client, and are they qualified to be appointed as the person representative of the estate. Other things you would need to have to open the estate are the funeral contract or bill, an approximate value of the assets, so you can determine whether it's going to be a small or regular estate that needs to be opened, and then supporting documentation for those assets, which would include the title of the vehicle, bank account statements showing that account was in the decedent's name, and showing the value of the property at the time of death. And you would also need names and addresses of the interested persons in the estate, which would include both legatees, so anyone that's going to be receiving something from the will, as well as heirs at law, so anyone that would be considered a person that's going to be inheriting from the estate would also need to be included on the list of interested persons. And lastly, some estates may require some fees. Some of the fees that you might expect to see when opening a estate are nominal or person representative bonds. These are more required for regular estates, but sometimes apply to small estates as well when the value of the estate property is over $10,000. Sometimes the register of wills will enforce a type of bond on those estates. And depending on the type of estate, a publication may also be required. For regular estates, it's required that a notice of appointment be published in the newspaper. So there will be a publication fee associated with that. And in some circumstances, a probate fee may also be necessary to pay. But here is the petition for probate. This is the document that's going to start the whole process. This is what you will need to file in order to open the estate. And as you can see, the form actually allows to be used for multiple different things. It can be used to be open a regular estate, small estate, a will of no estate, and limited orders. For a will of no estate, that's a circumstance where the decedent didn't have any probate assets. Everything's passing outside of the estate, but the person representative is still required to file that will with the register of wills. So that is a circumstance where you will see a will of no estate. And then limited orders is a process that the person representative or interested party of the estate can get a limited order from the orphans court to allow them to search for a will or to inquire financial institutions whether the person who has passed away has assets with their institution. So I will be talking about regular estates and small estates for this petition. Some of the information you will need, a lot of it is on the death certificate showing where the decedent resided when they passed away, their date of death. And then for number 4, that's also a very important question to fill out, because this is where you show why your client has the priority to be appointed as the person representative, whether it be stating my client is appointed through the last will and testament of the decedent, or showing that they have priority in according to the Estates and Trust article. Some other questions that are on this petition are to ensure that the first representative has not committed any crimes that would prohibit them from being eligible to be the first representative. So it's important to discuss that with the first representative that is inquiring to be appointed. And then there are some questions as well to dictate information about the will, as well as the names and addresses for the witnesses for that will. And then it's also important to note number 11 here, and indicating how you want this estate to proceed, whether you want it to proceed administratively. And that would be a situation where one is testate and your client is the first representative appointed in the will. Then you could proceed administratively. It could also be a situation where your client has the priority to become first representative. The situation that you would most likely need judicial probate is where the will can't be located, or your client doesn't have the priority, so you have to request judicial probate to go in front of the orphans court to be appointed at a hearing. And other examples that I've seen are defects with the will, or something that has or limited information about certain heirs. These are things that would cause a client to potentially have to go through judicial probate. So for a regular estate, a Schedule A would need to be accompanying the petition for probate. For the Schedule A, this is just an approximate value. So date of death values aren't necessary for this point in time. You're showing that the register, here's the approximate value of what we think the estate will be worth. And as you go forward, that will be, the date of death values will be shown on the inventory. So for just opening the estate for a regular estate, you just need to show the estimated value at that time. However, for Schedule Bs, for small estates, this is a little bit different from the Schedule A, where you do need to show date of death values and supporting documentation at this stage. So if it was a bank account, you would need to show the date of death value with a copy of that statement attached. If it was a piece of a property, then you would need to show either the appraisal or the tax valuation, showing how much that property is worth. And with small estates, if there is a mortgage involved with the property, that is something that would also need to be included here, especially if it is a sizable mortgage, because that is something that potentially reduces the value of the estate by that mortgage. So for example, if you had a piece of real property that was solely in the name of the decedent that was worth $100,000, and they had a mortgage on that property of $75,000, for the estate purposes, it would be valued at $25,000, and therefore would be able to proceed as a small estate. The next document that will also need to be filed is a list of interested persons. And like I said earlier, this would need to include both legatees if there was a will, as well as heirs at law, which would be anyone that could inherit from the estate through intestate succession. It's also important to note what kind of relationship they have with the decedent, whether it be an heir, legatee, first representative, because sometimes the interest person could be both, could be all of them. If the person that's appointed as the first representative is receiving something through the will, they would be, and they are the surviving spouse, for example, then they would be considered all three of those things. So it's important to note how that person relationship is with this estate. And here is just the form for the consent to appointment of personal representative. And this would only come up if it's someone trying to be appointed as a personal representative that isn't named in the will or doesn't have that priority that I was talking about earlier. And in this consent, they can also consent to the waiver of the personal representative bond. So say this is a regular estate, and your client is trying to be appointed as a personal representative. It would be a good idea to get consents from the remaining family and interested persons, so they don't have to get that expensive personal representative bond, and they would only be required to get the nominal bond, which is a lot less expensive for the client. It's usually around $100, and it just covers the court fees and the fees that would be owed to the Register of Wills. And here is the notice of appointment. This is the notice that gets published in the newspaper for Baltimore City. It's the Daily Record, and this gives information to creditors and unknown heirs that an estate has been opened, that there has been a personal representative appointed, and it gives some information about when the final opportunity for a claim against the estate will be filed. And I will be talking about claims later on in the training. And there is also a fee associated with the notice of appointment, which for Baltimore City, it's a Daily Record, which I believe is 120, but it will differ for county to county. This is the information report. So this is one of the documents that will need to be filed in both small and regular estates, but won't be due right at the beginning of the administration. And this form's primarily purpose is for the Register of Wills to be able to track if there's any inheritance tax owed in this estate that's happening outside of the estate with the non-probate assets. So it's going to ask various questions about if the decedent passed away with any property that was distributed to anyone that was exempt from the inheritance tax. And for our purposes, for estates currently, the only type of heirs that would be subject to inheritance tax would be collateral heirs, which would include like nieces and nephews, uncles and aunts. But again, I have a slide about that later on in the training. So the question was, how are personal property distributed and how are they valued? Is that so for personal property, if there is a will, there's usually a section of the will that handles how tangible personal property is to be distributed. And as for valuation, that's one thing that kind of differs a little bit from county to county. I know Prince George's County has a form that permits that the family agree on I believe that there's some kind of petition to allow a certain valuation of the personal property. Otherwise, it could be an appraisal that could be used for those type of assets. So it kind of just really depends on the situation and what's being distributed. And so if it's jewelry or expensive things like that, my recommendation would be to have that appraised so you have something concrete. But there is a way to also petition the court to have certain assets, like tangible personal property assets, valued in a certain way as well. Right. So for vehicles, there's also a similar way. You don't necessarily need to have that property appraised. You can use the Kelly Blue Book valuation or a similar valuation for that, and that would be used to determine the value for the estate purposes.
Like 3 or 4 siblings. But isn't it true? I always get into this like trouble. Isn't it true that like each sibling has to sign off on the consent? Like each like sibling, let's say a mom died and the dad's already previously. and now one of the siblings wants to be the first representative. Like in the case that you have multiple people who could be the PR, each of them have to sign off on the person trying to be the PR, correct?
So if they're all on the same level of
They're all on the
priority,
same level of priority, all siblings.
then the consent wouldn't be required for that person representative to be appointed.
Okay.
But it's absolutely a good idea
Okay.
it streamlines the process a bit,
Okay.
and avoids conflicts down the
Conflicts
road.
yeah,
So
okay.
it's always a good idea to get consents to be appointed, but not necessarily necessary when they have the same level of priority.
Yes.
Yeah. So the question was why the daily record for the notices for appointment and notices to creditor. I don't have a great answer for that. That has just been the publication that Baltimore City uses. Other counties has a little bit more flexibility. I know. I think it was Montgomery County that uses the Gazette. So it just kind of differs between counties, and I think it's just a preference for the register of wills, and I think they just have a relationship with the day record, and that's how it's been handled. So I really don't have a better answer than that. I believe that a lot of the notices are also on the register of wills, or yeah. So yeah, there is a way to look up the notices as well on the register of wills website. So the question was, what happens when you originally open a small estate and after finding more assets, it's going to be needed to change to a regular estate. So there is a process to petition to convert it into a regular estate. I believe another petition for probate would be required to be filed. So kind of starting back at beginning of the process when that kind of situation happens. Any other questions? Okay. So here is the basic estate administration timeline and important dates to keep in mind when representing a client for estate administration. So after filing the petition for probate, the list of interested persons, if it wasn't already filed with the initial petition, will be due 20 days after the date of appointment. And then 3 months from the date of appointment, the information report will be required to be filed. And for regular estates, the inventory will be due 3 months from the date of appointment. And the inventory is very similar to the Schedule B for small estates, where you're showing the date of death values for each asset that's being probated. I believe I have that on a slide. If not, I can send that out. And it's essentially just a schedule of all the assets that are going to be administered through the estate, broken down by different categories of assets. And then it's important to wait past the claim period. So the claim period is 6 months from the date of death. That is the last time normal creditors can file claims against the estate. So that would include credit cards, outstanding bills that the person might have. So regular claims against the estate would need to be filed within 6 months after the date of death. However, there is an exception to that, where the Department of Health can file their claim for the outstanding cost for Medicare, and their timeline is a little bit different. It's 6 months, 6 months from the date of appointment of the person representative, and it's based off the final publication in the newspaper for that appointment. And then for regular estates, one of the last important dates to keep in mind is after appointment, the accounting will be due in 9 months. And if there's a necessity for more than one account, say not everything has been finalized and you're still gathering information and still collecting assets at that time. And then, so in that situation, subsequent accounts will be due 6 months from the previous account until the estate has been finalized. So for insolvent estates, here is the payment schedule for that. And so when you have an estate that doesn't have enough assets to pay for all the expenses and all of the fees and all the distributions, this is the order of how those type of payments should be handled. The first is the fees that are due to the register. In order for them to stay operational, they need to be able to collect probate fees and fees that are owed in the estate. And then you would look at the costs and expenses of administration. These would be the usual necessary costs associated with the estate, whether it be probate fee or requesting the amount necessary to gain copies of the death certificate, or just fees that would pop up in the normal course of the administration that the person representative was required to pay to proceed with everything. Then you would pay the funeral expenses, compensation for PR and attorney's fees, and after that would be the family allowance. And you can see the rest on that, but the first 5 are the ones I like to focus on, as they are the ones that, from my experience, are the ones that are most common, the ones I've seen through the estates I administered. So the question was, what's the difference between small estate and a regular estate for accounting purposes? So for a small estate, the last filing will be the Schedule B. So there won't be an accounting necessary for a small estate. Small estates are kind of like an open and closed kind of process where you file to be appointed as the first representative. You show the assets of the estate, and then wait the 6-month creditor period to make sure there's no creditors in the estate, and then proceed to make distributions at that time. So there wouldn't be a formal accounting necessary for a small estate. That's only required for a regular estate, and then that would be due at 9 months after the appointment of the person representative. And this shows the amounts that would be owed for the probate fee for a regular estate, because the current law for small estates is that there is no probate fee owed. But if say you're opening an estate for someone who passed away 10 years ago, you would have to look at the standard that was 10 years ago to determine the probate fee for that estate. So if you have a small estate that had like $10,000 and the person passed away in 2000, that there might be a probate fee associated. But for everyone that has passed away currently from this day forward, there is not a probate fee for small estates. And for regular estates, the probate fee will be required to be paid once the first account has been filed, and it is determined by the gross value of the estate. And again, this is just the family allowances, and this is just additional allowance that the spouse and minor children would receive under those circumstances. For claims against the estate, like I said earlier, creditors only have 6 months from the date of death to file any claims. And if they do not file a claim within that time, they are barred from being able to collect that claim. And for the Department of Health, they can file within 6 months of the date of the final notice of appointment of a person representative's appointment. And one thing to to note about the Department of Health's claims is that there is a process to have their claim waived under certain circumstances in the estate. It's usually where the sole asset is a piece of property, and you want to keep that property in the family. So there is a process to have that claim waived in order to preserve that property for the family. There are a lot of other great resources to look into about that, as that's a little bit outside of today's scope. And another thing to discuss when talking about distribution is inheritance tax. So primarily, inheritance tax in Maryland only applies to nieces, nephews, and aunts, uncles, and cousins as of right now, the current law, and they are taxed at 10%. So if they were to receive $1,000 from the estate, or 100,000, then they would be taxed at 10%. So they would owe 10,000 in inheritance tax in that circumstance. But in the past, there has been an inheritance tax applied to both direct lineal heirs as well as siblings. So it kind of depends. If you are opening an estate during those time periods, then those inheritance tax provisions would still apply. For regular estates, the first representative is responsible for filing the administrative accounting. The accounting represents the estate's income, expenses, and distributions during the administration period. I do have an example to show you as well. And so let me pull it up as well. This was something that was on the Register of Wills website. They also have a lot of other great examples. All right, so here is a sample guide for filing accounts that is on the Register of Wills website. It is a little bit outdated, so keep that in mind, especially when looking at the page that discusses. I'm just going to scroll down real quick. So this is a bit outdated, talking about who will receive from the estate without a will. But for general purposes, this is a great guide to kind of see what a accounting would look like and what kind of things to expect would need to be included. So I'm just going to go through this real quick and kind of showcase some of the things that would need to be accounted for. So the beginning of the accounting is always going to show the assets that were shown on the inventory. And this is always the beginning process. These are the date of death values that were provided on the inventory, and that is how we get our beginning total for the estate. And other things that would need to be included are any kind of income or receipts that the estate has received. So if there are refunds for certain expenses or interest, then those things will need to be shown on the accounting. Also, changes of the asset value. So if you were to sell a piece of property for more or less than the value that was shown on the inventory, then that would need to be represented here in the accounting, and then you would need to show the gain that has occurred or the loss. Primarily, I see this a lot with real property. So if there's a piece of property in the estate, it will be, and it's sold, it would need to be shown what it sold for and how much it either lost or gained in this section. And again, income and interest would also need to be shown, and as well as expenses. So this is where the funeral expenses that were paid, expenses to maintain the property, any expenses that were paid to the register, or expenses for the bond or publication. These will all be listed here. And then once all the expenses are accounted for, there is the distribution section. This is where you would either look at the will to determine if there are any specific requests or general requests that need to be addressed here. And then for an intestate estate, you would, in this section, you would show, based on the heirs of that estate, what percentage of the estate they would receive. So a bit of an oversimplification for the accounting, but I wanted to just kind of showcase what one would look like. So you have a better idea of what kind of things need to be gathered and the information that needs to be provided for the auditors to approve the accounting. All right, and with final accountings, once the accounting has been reviewed and approved by the court, and no exceptions have been filed to the accounting, and the usual period for that is 20 days from the day the order was docketed by the Register of Wills, then at that time, the person representative can make distributions based on that accounting. I also wanted to include a bit of information about distributing property from an estate, especially real property. So the person representative would be required to do a deed, person representative deed, in order to effectively transfer the real property from the estate to the heir or legatee. The PRD will recite satisfaction of administration obligations. So that will be kind of stating that the person representative was appointed on this date, the estate was opened, this is the estate number. That kind of information would be included on the deed itself, as well as showing the authority of how this was transferred to the new owner of the property. So if it was something in the will, that would be shown on the PR deed saying, pursuant to the decedent's will, this property was bequested on to this heir. Or in the case of an intestate estate, you would show that the same exact thing, but based on the intestate succession, that is why they are receiving this piece of property. The PR deed is exempt from transfer and recreation taxes, but it is important to note there are some fees associated with filing the purchaser representative deed. One is the lien certificate. So in order to file the deed, you would need to get a lien certificate showing that there's no outstanding debts currently owed on the property. So that would be any outstanding property taxes that were due or water bill. Those are the two common ones I see. And then there also would be a recordation cost. And that's normally around $60, but it depends on the length of the deed and what is being filed with it. So that is mostly what I have prepared today for the overview of the estate administration process. Sure. So there are a lot of CLEs available. I know MVLS has done a few over the years as well on this topic. There are a lot of great CLEs through the MSBA. One that comes to mind is Gibber on the estate administration. It's a very all-inclusive training on A to Z estate administration. So that's one I highly recommend, as well as the Register of Wills. They are a great resource for practitioners as well as family members to utilize when dealing with estates. They have a lot of knowledge in this field and have a lot of experience working with family members, represented and unrepresented with these type of matters. So they are a great place to ask questions on this as well.
Can you speak to kind of perspective that you're coming from, and the perspective that MVLS is coming from? Like, what are some of the difficult challenges for our clients when going through processes like this?
Sure. So some of the challenges that I see in the the nonprofit world for estate administration is a lot of these costs are really kind of a barrier to entry for our clients, and um, they see these costs and they don't want to open the estate to get the title in their name. So that's how these issues kind of get dragged out, and why we see a lot of estates opening 20 years after the fact. But there is a waiver of some of those fees, at least the register wills fees. So if you are volunteering through either MVLS or senior legal services, there is an ability to waive those fees, since you're being represented by a public interest attorney, or if they fall within a certain amount of like poverty income limits. But that only waives the registrar wills fees, which would be like the probate fee. It doesn't waive the publication fees that are owed to like the daily record, or the bond fees. Those would still be required to pay, and that's where I see a lot of folks struggling to get the funds to either get the personal representative bond if they are trying to be appointed and they don't have consents from all the family members, and the court is enforcing a personal representative bond. And in some cases, even the number bond is a lot for folks to take on. So that's a lot of the struggle that I see in our office.
I think another issue.
Sure.
Do you have any advice when it comes to sort of the intersection with sort of family issues and counseling that like this type of work involve?
Yeah. This area does have a lot of emotion involved with it. It's especially with the passing of a relative, and tensions can be really high among family members. So it's really important to one, know who your client is. You're representing the personal representative of the estate, so you have to do what's best for the estate as a whole. Important to communicate what's happening directly with the personal representative, but also to kind of counsel the family through the process, keeping them aware of what's happening. I find that it's good to keep that open communication with the family, opposed to keeping them in the dark, because that's where I see most of the issues when things are happening in this state and the family doesn't know what's going on, and they start kind of second guessing everything that's occurring. So it's just really important to have your client communicate things to the family, keep them updated. But conflict is going to arise, and it's just kind of important to address it if need be. So the question was about real property, and if it was the sole asset, would the property need to be sold if there were expenses? That it depends. If the only expense is the mortgage, then the family member or the heirs at law that are inheriting the property could assume that mortgage if they have the ability to do so. So it's kind of a case by case situation there, whether they have the ability to assume that mortgage or not. And if they don't have the ability to assume that mortgage, then that's a situation where the property would need to be sold to prevent foreclosure. And I've seen estates that had a lot of claims and other expenses that need to be paid when the real property was the only asset. So in those circumstances, the property may need to be sold as well, unless one thing I have seen families do is kind of put up cash to into the estate to kind of pay for some of those expenses, so they weren't forced to sell. But I know a lot of clients don't have that benefit as well. So sometimes the property would need to be sold to pay those expenses. And the personal representative wouldn't necessarily need a court order to sell the property. They have authority to sell property once they get letters of administration. But if it was a circumstance where they were trying to sell it for below fair market value based on like the condition of the property, or if they were selling it below what the day of death value that was listed on the inventory, that those would be circumstances where they would need to get permission from the court to sell it for that kind of price. So again, I am from Senior Legal Services. We are a nonprofit that assists strictly seniors in Baltimore City. We are anyone that is 60 or older and also a resident in Baltimore City is eligible for our program to receive legal services. We're always looking for volunteers to assist us with estate planning or estate administration. We have a lot of clients that come to us with both those type of issues. So you could either give us a call. Our number is 410-396-1322 if you were interested in volunteering, or by reaching out to me and showing your interest in volunteering for estate planning, or whether it be estate administration. And if we have a case that comes up that would be good for a volunteer, we always try to kind of screen our cases that would be appropriate for a volunteer to take on. We wouldn't want to put the volunteer in a position where they might be handling a contested matter in an estate. So the ones that we would have volunteers assist us with would be more straightforward, just kind of the opening and more of the administrative estates. So yeah, the best way to reach us would be by calling, and we'd be happy to have volunteers assist us with these cases.
Thank you for everybody who is following along. If you have any further questions, please direct them to me, Stephen Coppin, which is scoppin@mvlslaw.org. Please feel free to reach out to us. MVLS is committed to expanding access to justice for Marylanders. We're so glad to put on this training as part of that mission. We really want to increase the accessibility, and I'm so glad that Nick Pycha was here to help with this, to increase the accessibility of estate administration for volunteers specifically, to get more people out there who can help clients like ours and other people who need this, because this is a very present issue in Maryland. So if you have any questions, please let me know. In any case, thanks for being here online or in person. We appreciate everyone. And we hope you all have a great day.